Hello, my name is Brandan Davies. I'm a criminal defense lawyer based out of Overland Park, Kansas. In this video, I'm going to talk a little bit about jury instructions, what they are, when they come into play, and how you can use them to your advantage in your trial. Now, jury instructions are a pretty simple thing. They're the pieces of paper, the instructions that go back with the jury and are read by the judge to the jury at the close of a trial. Now, these jury instructions are essentially to help guide the jurors on determining the case and let them know what the law is, what the burdens of proof are, and different things on how the trial or the verdict should be decided. Now, that's what jury instructions are. Now, when they first come into play is at the pretrial conference or slightly before the pretrial conference. At the final pretrial conference, the judge is going to have ordered that proposed jury instructions be submitted to the court. In other words, your side will present a set and the other side will present a set. And those are essentially to have the judge look at and decide where you agree on, what instructions you agree that should go back. Both sides of the jury instructions will be kind of litigated before the trial, and there will be some agreed upon instructions, and they'll wait till the end of the trial to get the final instructions to the jury. So now, creating jury instructions, submitting jury instructions, having them in front of the court, that all seems like a pretty basic process. But there is an opportunity sometimes to take advantage of this process. Let me give you one example of how you can utilize this process to your advantage. So in a criminal defense case, you have a jury instruction that you can submit to the court that basically admonishes the jury to not hold it against your client if they don't testify. Now, this is something that you can put in with your proposed jury instructions. Now, the other side is going to get a copy of your proposed jury instructions and they're going to read it. If they see in your jury instructions that there is an instruction about admonishing the jury to not hold it against your client if he testifies or not, that is going to key off that they're going to automatically think this person is not going to testify. This jury instruction was probably submitted for a reason so that if the person doesn't testify, the jury won't hold it against them. So when that prosecutor is looking through your jury instructions, they may read that instruction and think, good, I don't have to worry about this guy testifying. I don't have to prepare for this person testifying. That can be a tremendous advantage if your client does decide to testify or if your plan all along is to have them testify. Because this jury instruction will indicate to the prosecutor that they may not testify. And so that prosecutor won't have spent the hours necessary, or at least there is a hope that that prosecutor won't have spent the hours necessary to prepare for that examination. Having the prosecutor have to ask questions being unprepared can be a tremendous advantage for your criminal defendant if they do end up testifying. Now, this is just one way of utilizing this very small process in the criminal case to your advantage. Now, jury instructions and this process may seem like a very small part of the process, but the difference in being able to take advantages of small little pieces of the process can be the difference between a good lawyer and a great lawyer. If you have questions about your case, if you've been charged with a crime and you need help, feel free to contact my office at 913-451-9500. Thanks.